Good morning. We are going to go on the record in Warren v. Warren 2023 DM 298. Counsel, would you announce your appearances?
Susie Locke, the petitioner Scott Warren, who appears in my office.
All right.
May please the court, Your Honor. Matt Olson appears on behalf of the respondent, Idia Warren, who's also present with me in my office. And can you hear me okay? I'm kind of far back, so.
Yeah, we can hear you great. Okay. I believe, Ms. Locke, this is your motion.
Judge, yes, we filed a motion to settle the journal entry. We believe that the journal entry is accurate to the court's orders. I filed a Rule 170. Mr. Olson objected and filed a lengthy objection. I believe several of the issues have been resolved, but there are a few remaining issues. I will note that on Friday, he filed a response to our response to his objections and also produced 67 pages worth of exhibits. I have not had the opportunity to review those exhibits or discuss them with my client, but we are ready to proceed today and believe that the journal entry is ready to be finalized.
Sorry, Your Honor, I know you can hear me, probably see me. My computer in our conference room has gone back to the opening page. So I've got to try to find a password to log in. I'm sorry, we're having some IT issues this morning.
Is this causing any adversity currently to the clients? Do you want to reschedule this hearing when and you can check on your technology, but so that Ms. Locke, you can review his most recent pleading?
Judge, I've had time to review the pleading. It's the massive amount of exhibits that were given to me at 4 p.m. on Friday that I haven't had a chance to review, although I don't believe they're relevant to anything that's going to be before the court. Everything that should be argued today is legal argument related to what's proper in a journal entry and what the court has jurisdiction over.
My thought on that, Your Honor, is one, the majority of the exhibits we have are pleadings. I mean, it's the objections, the replies, the notice, it's the transcript from when we put this on the record. There's a proposed child support worksheet. And then the other things are health insurance verification, tuition payments that my client's been making throughout this year that she's not been reimbursed for. So none of these things are a surprise. The only thing that could be quote unquote a surprise are there's some images from Nigeria, where my client's family lives, that we have provided because there's been a pushback and a disagreement with respect to adding verbiage to the journal entry that would allow my client to travel to Nigeria with the minor child to see family because she's from there. So we've included a couple of 2-minute long videos, and then there's a couple of videos of Isabel playing with some cousins and whatnot from Nigeria. And so those are the only things that have been included. So I mean, our preference would be to try to get this resolved. You know, I don't think it's a big issue that are remaining. I mean, frankly, that's probably the biggest issue outstanding, is whether or not there'll be language that allows my client to travel to see family there, again, because she's from there, and then there's no plans to travel to date. It's just something that we want to have the option to do in the future. So that, I mean, the other outstanding issues are that whether or not my client, who's carrying secondary and health insurance for minor child, whether or not that would be included on in the child support worksheet, which we think is appropriate. And then the adoption of that child support worksheet. And I mean, then there's some other cleanup housekeeping items, such as some additional personal property that we wanted to include on behalf of the petitioner within the journal entry. And then there were some other changes, but I think Ms. Locke's already agreed to those, which again, I would categorize those changes as being common verbiage that when you settle a case in court, it's virtually impossible to get that language in every single sentence that's going to be put in a journal entry memorialized on the record. But they're common housekeeping items that you are included into a journal entry for purposes of getting a case resolved. So again, this has kind of been a holdup, I think, for both of the parties to try to get closure You know, we're ready to proceed. And again, I apologize, I'm having issues this morning. I've got a text out to get my screen back on, but at least we can still hear.
Well, I need you to explain to me, Ms. Locke, the benefit of secondary insurance in this case.
So, Your Honor, we submitted a child support worksheet to Mr. Olson with my client covering health insurance, which in the temporary order, he was ordered to cover health insurance. So he has been, since the parties separated, providing health insurance as the primary provider since the temporary order. So since this case started, it was agreed that he would continue to provide that. So he has continued to provide it. So it was included in the child support worksheet. Miss Warren took it upon herself to get secondary insurance coverage. Since this case started, she's had 3 different employers. My client has had the same employer, so he continues to have the same insurance coverage. She's had 3 different coverages. We're not opposed to her having secondary insurance coverage, but I don't understand why she should get a credit for that on the child support worksheet. This is not a best interest of the child question. It truly is an order to allow for secondary coverage, which no court is going to say you can't have secondary coverage on your child. But she shouldn't get a credit on the child support worksheet for providing insurance that she has no obligation to provide. And really, that has been one of the primary hangups that has resulted in this trickle down of her paying additional tuition, things like that. So our preference is that the child support worksheet be ordered consistent with the order, which is my client provides primary health insurance coverage and gets the credit on the child support worksheet for that.
All right, Mr. Olson, explain to me why your client is so adamant about having this coverage.
Well, hers is cheaper, Your Honor. So obviously normally the analysis we go through is what not call it an analysis. It's not even really that. It's, you know, somebody's got cheaper health insurance. Why would we not be saving everyone money and using that instead of trying to fight over that issue? Because as Ms. Locke has set out, there's been at least a little period of time the petitioner's been paying it. We've wanted to include it just because, you know, there's never a, but there are times that happen, and I don't profess to have any serious background understanding of both parties' health insurance coverages and what is covered, what are co-payments, what are deductibles, you know, all of those things. But there are times that we all are aware of that happen that insurance A may have less coverage than insurance B, and if you process a claim or whatever it may be through both insurances, it ends up costing both parties less money. The reality of it is, Your Honor, the court has the discretion to allow this within the child support guidelines if it chooses. Probably the biggest, if you want to call it, argument I can make to the court about this is it makes a $54 a month difference in child support. $54, that's all we're talking about here. And frankly, I haven't talked with my client about it. But I would suspect even if the court doesn't include it in here, since it is only $54 difference in child support, she's probably still going to provide the coverage. I just think it's more appropriate and fair to have both of them on there and have both included with the child support worksheet. And maybe to get a little sidetracked, but you know, again, my client's paying a lot of money for tuition for the minor child to go to private school. That was agreed upon. She's done that. The minor child's attended private school and have been doing that. That's not something new. And so the point being, this child support is important for her because it does subsidize those payments, those tuition payments. I mean, even in the last couple of weeks, there's a $500 fee you have to pay that's in addition to the tuition that's paid every year, you know, to reserve the child's spot. There's another $750, I think, that was the initial payment for this upcoming school year. So anyway, there's a lot of costs, which my client's been paying throughout 2025 without any reimbursement to date. So again, sorry, I'm getting sidetracked, but it's such a nominal amount of change in the monthly child support obligation. Why would we not include it? And the court has the discretion to do that. And my client's health insurance is not unknown. You know, she's had health insurance coverage. The dispute has come is that she's had, I think, two jobs or 3 jobs during the pendency of this case. And so the claim is that, well, she moves jobs a lot. We don't want the fluctuation in insurance, or she may not have it, whatever it may be. But her health insurance coverage is cheaper. The court has the discretion to include it within the child support worksheet. And it's such a nominal difference in the monthly obligation. Why would we not have it included?
All right, Ms. Locke, how much is your client getting as a offset for his premium for the child?
Just one moment, Your Honor, let me pull that up. He pays $331 for support. And Matt and I might have actually discussed that. Let me just say. $274, sorry, Your Honor, there was a change in support that Mr. Olson and I had already discussed. So he is getting a credit of $107, paying the $274, and then he ultimately gets a portion of that back on the worksheet.
Well, how much is just for the child and how much is for him?
That's just for the child. The $274 a month is just for the child. It's medical, dental, vision.
Mr. Olson, is hers medical, dental, vision?
Yes. Yes, Your Honor.
Does she pay less as a secondary insurance or the same amount that she would pay if it were primary?
I think it's the same amount, Your Honor. And we did provide, for what it's worth, in Exhibit F, and I understand Ms. Locke's got an objection, but there's a breakdown of the health insurance coverage monthly for my client. But it's the same regardless. Sorry, that's to answer your question.
Your Honor, may I briefly respond to Mr. Olson?
Sure.
So the child support worksheet that was drafted and provided almost immediately following the hearing takes care of the tuition aspect. It has him cost sharing in the tuition. Rather than adopt the child support worksheet that was provided with this discrepancy of $54 for secondary insurance, which would have shared in the tuition payments, we're fighting 3 months later about secondary insurance coverage. So there's this argument that somehow she's been burdened by these tuition payments, but it's her very own argument about secondary insurance coverage, which she is not ordered to provide, that has prevented the child support worksheet from being ordered. So the challenge that we're having is we want this case fully resolved and we're ready to get it fully resolved. But she is not ordered to pay secondary insurance. She's not ordered to provide that coverage in any way. My client is, it's included in the child support worksheet. So is the school tuition. So the child support issue should be a non-issue and it should be resolved.
Well, counsel, what I don't have before me, what normally I would do or ask you to do is normally I would look at how much is the premium, how much is the out of pocket, how much is the out of pocket copay max, how much, what kind of prescription coverage is there, what kind of dental, what kind of vision, and I would compare both policies to see what you get the most bang for your buck. So it isn't necessarily how much the premiums are, as much as overall, what is the best policy for the child?
And it's never been an issue. It's never been a question. Throughout the whole temporary order, my client has provided the insurance coverage, and there's never been a question of what's the deductible? How much will this pay? Her insurance provides X. This only came up post journal entry, like post providing the Rule 170. That is the only time her insurance has ever been discussed in this case.
Your Honor, I would say, well, Exhibit F, base stamp page 60, does have a breakdown of my client's. It's a $2,000 deductible. So it has a little bit of that information. It's a $63. Well, I'm sorry. There is a bigger breakdown too, as far as eye exams with the copay, and some additional information on the dental portion of it. I don't think it's quite what the court was asking for, but it does provide a little bit of a synopsis of that. Your Honor, I mean, January was long enough. Yeah, I can't specifically tell the court I recall whether or not we discussed this or not. I know one put on the record, but I was also reiterate that there are a number of what I would categorize as, not substantive, but maybe side issues or things such of this nature that either are briefly discussed or not memorialized when they're particularly put on the record. It's a very difficult task for, not only in court, but for both of the attorneys to get every single possible, either scenario or the provision that comes into play when you're trying to resolve a divorce, and to get every single one of those put on the record. I mean, my client's always had health insurance throughout the duration of it, and I believe the minor child's always been covered under her health insurance as well. So again, I'll go back to the fact that this is a $54 a month difference in child support. And it's good coverage. It's cheaper, again, than petitioners. We're not asking that my client be the one to provide health insurance now. We don't consider petitioners. We're just asking for it to be included as secondary insurance coverage, and that it just be included on the child support worksheet as well.
The other thing I could do is just say they both can pay for the insurance, and nobody gets a credit for anything on the worksheet.
Absolutely.
But the problem is then I have to order them both to provide insurance, because I can't run the risk of each one of them saying, well, forget it now, I'm not gonna pay, and then the child have no insurance at all. What is the breakdown of unpaid insurance? Or is it 50-50, or is it based on worksheet percentage?
For unreimbursed medical?
I'm sorry, Susie, I didn't hear you.
Sorry, Judge, are you asking about unreimbursed medical?
Yes, uncovered.
Yeah,
Sure.
it's based on the worksheet percentage.
92.
Which is 30, it's 40-60 essentially, or 39-61. Mr. Warren being the 39 and the respondent being the 61.
Well, I'm not going to give her credit for the secondary insurance because I'm not ordering that she require it, but the split's going to be 50-50 for any uncovered medical. So if she wants to have it so that it reduces any potential exposure for out of pocket for her, that's fine. If she doesn't, then he doesn't get the benefit of her secondary coverage in terms of him paying 39%. He's going to pay 50%. So it's a 50-50 split. Now, Ms. Locke, I'm going to tell you my theory behind some of the decisions I make when I make them, as best I can, if it makes sense to you. And then you can explain to me, I mean, I understand your objections to going to a country that has a, level 3 or whatever alert. But my position has been on a lot of issues, whether it be where parties can live, whether it be who children can have contact with. It happens a lot in paternity actions where the parties never really live together and never co-parent because sometimes they never even spent much time together. But I take a position that there's certain things that you do in life that you enter into that or you should know are part of the relationship. In other words, if you marry someone that is from a foreign country, or her immediate family lives in a foreign country, and you know that when you meet her, and you know that when you marry her, and you know that when you have a child with her, your expectation should be that child is going to travel to Nigeria and have a relationship with the mother's family. Now, this is not just specific to you. I have cases where someone is from Mexico, or someone wants to move closer to their family after a breakup, and the other party acts as if, you know, there's no family ties or no reason that the person would take the child there. I look at, what did you know about the person and the relationship when you entered into it? What did you know about the circumstances, the entire circumstances of the situation when you had a child together? And what could you reasonably expect may come of that? And to me, this is one of those things that your client should know, that he had a child with a person whose family, and I don't know if she's actually dual citizenship or she was born in Nigeria. I don't know where she was born, but the point is there's immediate family there. That is part of his daughter's culture. It's part of her background, and it's part of her history. And so I'm not sure why he's objecting. There's no evidence that she is threatened to run with the child. She has a good job. She got a great education. She's a pharmacist. Why would she throw all of that away? I mean, I understand your argument about The Hague. I understand your argument about there are certain areas that are high conflict that are more dangerous than others. But when you put it in the perspective of, this is a child who is equally from the mother's heritage, background, nationality, and the child has a right to explore the country that her grandparents are from, or whatever the case may be. I know I'm probably not being accurate with all the particulars, but the point is, I'm not, now that he's divorced from her, he can't just erase what he wants to erase from his child's life.
May I respond, Judge?
Yes.
And I 100% agree generally with the court sentiments that that's not an aspect of a child's life or the history that should be eliminated. Our challenge here is the parents have never gone to Nigeria together. They have gone to Ghana. We have specifically stated that we have no issue with Ghana. There's no concerns about that because the parents have been there together before having children. That is where the respondent generally lived, is my understanding. She was born in Nigeria, but never actually lived there. The respondent, to our knowledge, in 12 years has not been to Nigeria. Her father, who lives in the United States, does not have a relationship with his family. He does not go back to Nigeria. The concern is that there aren't true connections with Nigeria. There might be family there, that the bigger connections are in Ghana, and that Nigeria is not part of the Hague Convention. And I appreciate the court sentiment that this mom has never attempted to take her child. But for the first 11 days when this case was pending in August of 2023, she took the child from my client, would not tell him where she was, would not allow any contact, would not answer phone calls. So while it's accurate that since then they've been able to work through these issues, that is a serious concern. And the idea that she could, in a 14 days drop of the hat, get her daughter the 10 shots that are required to travel internationally and go to a country that she has limited ties to and that she would have no obligation to bring the child back from, that's a huge concern. There's no concern about sharing the culture, about encouraging their daughter, Isabel, to participate in the culture and with the family. But we think that can be done in a much safer mechanism, especially in Ghana, where we know the respondent has ties, that is a party to the Hague Convention, and that can allow for that travel to Africa in a much more safe way.
Mr. Olson?
Well, number one, my client lived in Nigeria till she was 7. Her father's family is from there. They own land. And again, I understand that Ms. Locke has a running objection with respect to exhibits. The 2 videos that the 2.5 minutes in length roughly that we provided with an individual driving around in Nigeria are from her father. So he's commonly there. And again, my client lived there till she was 7. The other point, at least during the issue brought up at the beginning of this case being filed, I don't, again, I was not the attorney of record entered. I don't think it's worthwhile to rehash things from 2 years ago, especially when we're at here now. But Judge, there was never a request that the minor child's passport be kept away or locked up in a safe, or the common ways we deal with situations in a divorce where one parent is from a country that's not part of the Hague Convention and there are legitimate concerns that that parent may flee. It was never brought up remotely during the pendency of this case. It's only being brought up now. The parties didn't travel to Nigeria when they're married because, one, they were only married for 5 years. Travel there is not just a, hey, let's go for a weekend, or frankly, even for a week. It's on the other side of the planet, and it takes, usually those types of trips, you have to schedule a significant amount of time. I would tell the court right now, my client doesn't have any trips planned to Nigeria in the foreseeable future with the minor child, but she wants the option to be able to do that. But again, the child's had some relationship and some time with cousins that have come here that she spent time with. That's another video that we provided. The other video shows the minor child, learning her native language and singing a couple of songs from that native language is very important. And I mean, the court's already kind of hit on the other, I think, big aspect of this that I was going to point out is that, again, my client's a pharmacist. She's put a lot of work in to be here, to have a career, to live her life here. That's not something that she's going to throw away and run away from. So, and again, understanding some of the arguments and comments about Nigeria and it being dangerous, and I mean that goes for any country. Frankly, I mean, living in Wichita, Kansas, I think we would all agree is significantly different than living on the south side of Chicago or in Detroit and south central LA. There are plenty of places in the United States that are very dangerous as well. But we don't prevent people from traveling to go to Los Angeles because there's a high murder rate there, or vice versa with Chicago, which I think has the highest murder rate in the country every year. So, the place that the part of Nigeria where her family lives, there are not issues with that any more than what the United States has. As you can see from the videos, it's not a dilapidated, I'm not trying to be disrespectful, but dilapidated third world country. But again, as the court has already said, this is something that you get what you bargain for. You go into this relationship, or you go into a relationship with somebody, and you get what you get the individual you get. And if you're married to somebody that's from a country such as Nigeria, and then you have a child with them, I think it's a little disingenuous in the context of after a divorce, to try to prevent the child from being able to go there to spend time with her family and with her heritage, which I think is extremely important for the development of any child. So, I'm not saying that there shouldn't be some parameters, or that my client's agreeable to, notification and, any number of things, if that helps ease the petitioner's concern before she travels, if and when she does. But she wants to have the option. And I think that that's more than appropriate given the circumstances that we have here. And again, we're asking that the court allow for that to happen.
Judge, can I ask a clarifying question?
Sure.
My understanding of Mr. Olson's position was that in emergency situations, Miss Warren should be allowed to take the child immediately to Africa.
I'm not going to allow that.
And that was our primary objection, that in an emergency, there would be no travel to any country that wasn't a signer of the Hague Convention.
I think that there should be a minimum of 30 days notice.
The only response I'm fine with that, Your Honor, but if there's a death or something like that, but if that's the court's order, that's the court order. I think we would be fine with that.
And that would give somebody 10 days to file an objection and to get a hearing in front of me. if there was something special going on.
The parties had agreed previously to 60 days notice.
Okay, that sounds even
ra-
better.
Rather than the 90 days, which had already been agreed on in domestic conciliation was 90 days. They agreed to modify that to 60 days. But Mr. Olson was pushing for this emergency situation definition that would allow to travel without any notice, which was our biggest heartburn, was we didn't want any travel to a country that's not a signer of the Hague or any international travel really at all without notice.
Your Honor, my preference would be 30. I think, if there needs to be a motion filed or this needs to be addressed by the court, that 30 days is sufficient notice that we can bring it in front of you before that trial
Back
goes to occur.
to 90, if that's what was negotiated. I don't want them to feel like they can just keep raising issues that have already been agreed to or resolved. The problem, I think what I'm gonna do is split the difference, 45 days, because that gives 2 weeks at a minimum for the court to get a hearing. 30 days is what I'd prefer, but my fear is by the time they get back to an attorney, they have a meeting with the attorney, they file an objection, and it's scheduled for hearing. We may be having a hearing 3 days before she's scheduled to travel. And I think 45 days gives enough notice that she can still book things within 30 days. I can't imagine going to another country and not planning it for at least 30 days. I understand about deaths. I don't, yeah, every culture is different, in terms of how quickly, they have services, how long the services are. I have a niece and nephew who are Samoan funerals last 2 weeks. And there's a lot that goes into them ritual wise. So I don't profess to know about all the different countries or, how they have the funerals, whether the body's present, whether it's embalmed. I mean, I just don't know enough. But she's so little too. I don't even know how much they want her directly involved in that kind of thing, depending. I don't know. If there's an emergency, you're just gonna have to file for an emergency request if they can't agree. What if it's 45 days notice, what do you want the objection period to be? Ms. Locke?
Your Honor, their agreement in DC was that you would give 90 days notice, the parties would talk about it, and then consent would not be unreasonably withheld. That was their agreement in domestic conciliation. Now that'll be shortened to 45 days, but I think those same parameters would apply.
Okay. Well, it probably should say any objection to the notice should be no later than 14 days. And the parties can demand an immediate hearing. I want to look at your response, Ms. Locke, again here real quick. What else, if anything, is an issue or do you foresee being an issue?
The only other,
Sure.
folks, go ahead, Susie.
So the next item that I have is the retroactive application of support. There's never been a journal entry finalizing child support. The law says that support commences at the court's order. And so our proposal is that child support would start as soon as the court's order is entered. And I believe that the respondent's position is that it should be retroactive to the trial date.
The only response I have to that, Your Honor, is my client to date has paid $4,092 January through March. Actually, not to date, that's at least January through March. Now there's some additional costs she's paid, as I mentioned earlier in this hearing, but paid $4,092 for tuition for the minor child. She's not gotten any child support. So that, again, with the goal being that there's an offset to those tuition payments through this child support order, we had requested that the child support amount be implemented effective February 1st. If the court's inclined to do it effective April or May, then again, this is probably even more outside of the scope of what we discussed and agreed upon in January. Then, you know, we're going to ask for some type of reimbursement for the tuition payments that my client has paid. So again, I think it's a lot easier and cleaner to have it the modification be effective, excuse me, I can't speak, February 1st.
And
well, I'm gonna order it effective April 1st. And part of that is because she wasn't ordered to pay health insurance. So the delay on the journal entry with regard to that was prompted by a desire, not an obligation. And secondly, they'd already negotiated the 90 days. Now, I understand there's some other issues, though, that you did resolve and agree to from the journal entry. I don't know how significant those were. Obviously, you were able to work that out. But I think some of the delays just been caused by your client not wanting to sign off on everything. And so I'm going to make it retroactive to April 1st.
then the next item, Your Honor, is personal property. The respondent wanted personal property included in the journal entry that my client does not own and has never claimed to own. We objected to those items being included. And then obviously it's now here before the court. But our position is that the court doesn't have jurisdiction over personal property that my client doesn't own, and therefore it cannot be included in the journal entry.
Your Honor, I would save your time. I don't, if that's Ms. Locke's client's position, I mean, arguably to his benefit, including that, we're fine if we leave that out. That's okay.
Okay.
And then, Judge, the only remaining item is there was a late addition to the journal entry proposal that there be some requirement that my client cannot go to Ms. Warren's place of work. The most recent ideation of that is that he is not allowed to go to any Dillon's pharmacy, which everyone from this area knows that the Dillon's pharmacies are in the Dillon's. That essentially would be preventing him from going to 16 Dillon's in the Wichita metro area, because she travels, meaning she's not at any regular store. The pharmacy is in the Dillon's, and she doesn't want to have any obligation to inform the petitioner of which store she's working in. So essentially the respondent's position is that for no apparent reason, my client should not be allowed to shop at Dillon's.
Well, if you're in El Dorado, when Walgreens closed, your only choices are Dillon's and Walmart and True Care. So Walgreens has taken some off the table, but where does your client get his prescriptions? I mean, if he's picking up prescriptions for the daughter, he's going to go to a Dillon's pharmacy.
And
This is
and
Wichita, Your Honor. I would just say that. I'm sorry for interrupting.
yeah, he doesn't typically use the Dillon's pharmacy, but the position is that he not be allowed to Dillon's pharmacies, which are in Dillon's. So I don't know how you enforce that other than he can't go in Dillon's. The issue that they're alleging happened, he stopped in a Walgreens store after an exchange, during which he had exchanged their child with the respondent's father. And he stopped in a Walgreens store to get some vertigo medication and a drink. And he never even saw the respondent, didn't know she was working there. He did see her father in the store. And then she made this allegation that he was stalking her, which was not true. He simply stopped in the pharmacy to get some vertigo meds and a Gatorade. And now we have this idea that he wouldn't be able to go to any Dillon's in the Wichita area.
I mean, that'd be ridiculous. Again, it's not like we have a lot of options for grocery stores, and you usually go to the one that's closest to you, unless you, I don't know, some people shop around so they can go to Aldi's or somewhere and save money. Some people go to 5 different stores, depending on what they purchase, where to save money, and drive all over. I mean, he's going to be allowed to go to the Dillon's. And I just understand why, if he just fills a prescription and there are videos everywhere, there are videos all around the pharmacies to make sure people don't rob the pharmacies. If he's conducting himself in a professional manner, and she is too, I don't really see what the problem is. But if it's not his, nowadays people even have to pick pharmacies based on their prescription coverage. I mean, if you have TRICARE, there are certain places you can't go, and they don't accept your coverage. I mean, how can we limit if, again, people are trying to get the most for their money, as they should, and people should be acting in the best interest of their children. So I'm definitely not going to limit him that he can't go into a Dillon's store, and he's not even going to know what one she's in at any particular time, potentially. But Mr. Olson, what is your response with regard to him being a patron of the pharmacy itself?
I think one, again, I was trying to avoid rehashing things that have gone on during the pendency of a divorce, because clearly the hope is the parties are moving past that. The event that's been referenced was from May of last year, and the concern my client had is obviously being familiar with where the petitioner lives, and in conjunction to where she was working at the time, he would have passed at least two different pharmacies to be able to pick up the stuff that was not prescription based, the stuff that he bought in her pharmacies. The request I feel like is much more, you want to say, neutral than what's being discussed. It would be that neither party's to be at the other party's place of employment. Now, obviously, that does put a little kink in it. I mean, I guess the argument I have for the court is, I think you can still very much be in a Dillon's without being near the pharmacy. The pharmacies are all located in the same spot. They're not in the middle of the store. Knowing the layout of the pharmacy in the Dillon's in El Dorado, as opposed to the pharmacy at the Dillon's at Central and Rock, which is about the size of Town East. I mean, you can very well do all the shopping you would need without having to be near the pharmacy. So I don't think it even needs to be a provision that would ban the petitioner from being in a Dillon's store. Just don't be at the pharmacy, because she's working there. And I think anybody, if they're cognizant of not trying to create or cause problems, I mean, I think you could very well follow through on that order without violating it. So again, the request isn't that it be banned from a Dillon's, but again, I understand where the court's coming from. I would say there are a lot of pharmacies in Wichita. You've got Walmart, you've got Dillon's, you've got Dandarin, you've got Walgreens, you've got, and then there's a bunch of mom and pop shops as well. So I don't think it would be any type of real detriment to the petitioner. And again, we're not asking it just apply to the petitioner, it'll apply to both parties, which I think is fair. So obviously the goal here is not to create things that will create more litigation in the future, which I think is always something I try to do when wrapping these types of cases up as best we can, with the court having continuing jurisdiction. The goal is actually the opposite of that, is to try to prevent issues from coming up. So I think it can be accomplished. My client does rotate Dillon stores. I know that makes it a little bit more difficult, but I think you can very well go into the Dillons. And again, I don't profess to have been in every single Dillons in Wichita right now. I think there were a couple of smaller ones at some point in time in the past. I think those have closed down. I think most of the Dillons within Wichita are a very large or pretty big. You know, I think the one in El Dorado is pretty good size that you can do your shopping without being near the pharmacy. So I mean, that was the basis for the request, Your Honor. One thing I would add, I didn't say, there was a PFA during the pendency of this case. I think that got resolved. Again, I wasn't the attorney of record, but there has been some concerns with, and again, I'm not trying to rehash the 2 years that this case was pending from where we're at now, but there were concerns for my client during the pendency of this case that the petitioner was following her and was in places that she felt uncomfortable that he was at. And it was an attempt to try to alleviate that from occurring, frankly, for both parties as we move forward.
Well, first of all, Mr. Olson, I'm rarely at a pharmacy where the pharmacist is up at the front desk. Sometimes they can be seen if you know who they are, but they're behind the scenes. Secondly, Ms. Locke, if I were your client, I'm not sure that I would want to go to a pharmacy where potentially my ex-wife is doling out my medications. I am not going to restrict him from being in Dillon's. And the other issue, though, Mr. Olson, is, from my experience, occasionally I'll get a prescription for a new med to try that is $300, $400, $500, $600. And so you have to look at where you can get discounts, where you can get coupons. What costs do vary, especially from pharmacies to pharmacies. And so I'm not sure why I would prevent him from filling a prescription at some Dillon's if it saves him money for himself, for the child. Again, though, Ms. Locke, I don't know why your client would even run any risk of her reporting that he is harassing her at work. I hope to see the parties get past all of this. So I guess the order is going to have to say that in order for him to use a Dillon's pharmacy, he is going to have to contact the store manager and verify she's not working that day and pick up the prescription when she's not the pharmacist on duty. But I'm not going to prevent him from being in Dillon's.
So this is only if he's going to fill a prescription at Dillon's?
Yes, because the over-the-counter, there's no way to enforce the over-the-counter meds are adjacent to where the pharmacy is. And again, he may pick up Tylenol for the child, or he may pick up other things while he's at the grocery store. I do think most of the pharmacies have glass or walls. I mean, she's certainly protected back there. They're usually not all open spaces. And like I said, the pharmacist usually isn't at the very forefront of the store or checking people out. If you need consultation by a pharmacist, they may be called and come to the front of the store, but that's not where the majority of their work is taking place. So he shouldn't be up at the counter filling a prescription on the day that she's working at that particular pharmacy, but he can be in the Dillon stores. And if he needs to fill a prescription at Dillon's, then he needs to show evidence that he called ahead of time and confirm that she would not be the pharmacist on duty at that store at that time.
Your Honor, may we request that she have an obligation to tell us about any job change? During the course of this case, she's worked at Walgreens pharmacies, she's worked at Walmart and Sam's Club pharmacies, and she's worked at Dillon's pharmacies. And so We don't want this to apply only to Dylan. She moves pharmacies and now she's working at his regular pharmacy and we have an issue.
Don't you think for purposes of child support, et cetera, they should give notice of changes in employment?
Yes, but it has not occurred in this case. And so I don't think there's any harm in writing it into the order.
Okay, that's fine.
Well, yeah,
I
Oh,
do
sorry.
think there are certain folks that need as much in black and white as possible. And unfortunately, they're one of those couples, I think. So, Mr. Olson, what were you going to say? I'm sorry.
Sorry, Judge, I just said the court hit what I was saying, so I apologize. I mean, if she's obligated to under the guidelines, if there needs to be another provision in it anyway, I mean, it's reiterating what she's already obligated to do. That's fine. That's fine.
Okay. Now, you two are not operating though on this employment thing. I mean, you're not right. Are you writing this in as if it's a restraining order such that it's a arrestable offense, or are you writing it in as it could be the basis for contempt?
I would be writing it in as just like a contact restriction that would essentially be a violation of the order.
Okay.
Yeah.
All right.
I don't believe there were any other objections that haven't already been resolved by agreement, but I will let Mr. Olson let me know if I missed one.
No, I think we're good, Your Honor.
All right. All right. Good luck to the both of you. I hope your summer goes well. You have a beautiful daughter. Pictures are adorable. So, and I'm sure she loves both of you. So, I do think I think it's time well spent, to make sure that we have as much, in the decree as possible. And hopefully though there's some guidance to you on any issue that develops, and or you can negotiate through your counsel. All right. Okay, if there's